Mr. Boyer is present here in the courtroom today.
We are here today for status conference. We do have an offer from the prosecutor, which we would seek to take advantage of. That offer contemplates an admission to the domestic violence offense, which is, I believe, count 2.
Got that as count 1.
With a dismissal of habitual fourth offender notice. As well as the resisting instruction.
That is a correct statement of the offer. It was a plea to domestic violence, third offense, dismiss the habitual, dismiss the RNO.
Just for the record, I just want to make sure we're correct. I have the information as a third offense is being dismissed. Correct.
And Your Honor, I apologize. I think from the felony complaint to the felony information, there's some differences.
Okay.
So it would be count 1 with a dismissal of the habitual offender, as well as count 2. That would contemplate a plea to the 5-year felony. That would be a no contest plea, and I have the interim complaint, an affidavit for the court in terms of factual basis.
And Ms. Coe, do you have an objection to the no contest plea?
No.
What is the basis for the no contest?
Your Honor, Mr. Boyer has a long history of mental health issues, which frankly we're going to address to the court a little bit later in the hearing. He does not have a clear recollection of everything that happened.
Ms. Coe, do you have any reason to object to the basis for the no contest plea?
No.
Mr. Boyer, have you had an adequate opportunity to speak with your attorney about this plea agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Raise your right hand. Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Boyer, are you currently on any kind of probation or parole?
No, sir.
You understand that by pleading guilty to no contest to domestic violence third offense, that the maximum possible penalty you can face would be up to 5 years or a $5,000 fine.
Yes, sir.
With that in mind, what is your plea for that charge today?
No contest.
All right, I'm gonna go through your rights with you. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you. The right to testify yourself at a trial if you want it. You understand all those rights.
Yes, sir.
You understand you're going to be giving up and waiving all of those rights by pleading no contest.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making today or to try to get it reversed. Wanted to try to do that, you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anybody promised you anything other than what we've said here in court?
No, sir.
Your own free choice to enter this plea.
Yes, sir.
Right. Have you reviewed the complaint and affidavit?
I have.
Information contained within there which provide a factual basis for finding that the defendant is charged.
Yes.
Mr. True should be done that as well.
I have.
Would you agree that it would provide a factual basis?
Yes.
I would.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. True, are you?
No, but I do, before we go any further, I do think we probably need to ask him about the prior offenses, the prior domestic violence.
Mr. Poirier, were you previously convicted of domestic violence back in 2013 in District Court in Roscommon County?
Yes, sir, sounds good.
And then also in 2017, also in Roscommon?
That's possible. Sir,
If the records indicate that, do you have any reason to doubt that?
no, sir.
Mr. Truce with that?
I think that we would have a factual basis.
Mr. Truce, are you aware of any threats, promises, or inducements other than what's took place on the record?
No,
And both counsel, are you both satisfied that the court has complied with statute and court rule in the taking of this no contest plea?
Yes, Your Honor.
I am satisfied.
Mr. Poirier, the court finds that your plea is knowing, voluntary. I'm going to mark that complaint and affidavit as court exhibit 1 and admit that as evidence in the file. Court has reviewed that. I'm satisfied based on information contained within court exhibit 1 that would establish a factual basis that you are guilty of this charge. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, someone from the probation department is going to be looking for a pre-sentence report. You'll have a chance to go through that with Mr. Truce prior to the sentencing hearing. Mr. Truce, anything else we need to address with the record today?
Yeah, sure. I did want to address bond. I have a few documents for the court. I'm providing the same to the prosecutor. The first is a letter from his counselor, Mr. Gant, who he was seeing at the time of this event. The second is going to be a message from Mr. Gant, a text message from Mr. Gant to Mr. Poirier, basically identifying that his depression, anxiety, and ADHD were out of control, and that that basically every time that Mr. Gant had seen him change medications. The third document is a diversion plan from CMH, signed by both the CMH jail specialist as well as Mr. Poirier. I'm going to provide all those to the court. Okay. Once the court's had an opportunity to review them, I'll address it directly. So, Your Honor, I would ask court to consider amending the bond to allow for Mr. Poirier to be released, specifically to be released and follow the diversion program that's been created by CMH. Obviously, from our perspective, the opportunity to show the court that the diversion plan is viable and working prior to sentencing would be very valuable, but I think at a fundamental level, Mr. Poirier being in the jail is somewhat of a disservice, and he has significant mental health issues. Certainly, I understand, and I know the prosecutor is going to say that there's history here, and there certainly is. We don't deny that. But he has significant mental health issues. At the time that this occurred, he was seeing Mr. Gant, but frankly, it was essentially a teledoc situation, meaning he was not meeting him in person. Everything was being done either telephonically or via Zoom. Frankly, based on what the jail staff and CMH are indicating, it sounds like Mr. Poirier was being over-medicated at the time, which we all know can create just as many problems as being under-medicated. They were working off of a psychological assessment that was frankly 5+ years old at the time. I really think that Mr. Poyer is someone who, with the proper mental health intervention, can be a successful member of society, but I think it's got, one, for his type of issues, I think it's got to be face-to-face. I can appreciate how teleconferencing technology is helpful for all sorts of things. I don't see how it can be effective for this type of situation. So I would ask court to consider modifying the bond or reinstating the bond, I should probably say, so that he could participate in that program, be able to show the court that not only is this plan viable and effective, but he could comply with it given the opportunity to. Thank you.
Let's go.
Your Honor, I would absolutely disagree. For one, Mr. Porter has a bad attendance record. And I believe it was indicated he has some type of thing where he won't come in public. But when you look at his criminal history, which is very assaultive, it's a long assaultive history. It involves egg stalking, several DVs, UDAA. There's some pretty serious juvenile cases in there. He had an assault by strangulation. It looks to me, when I look at his criminal history, that he went to prison for that in 2017. I don't know when he was released because it doesn't say. While he was on bond, he broke into a building in town. When this happened, his parents, who I've had a talk with just recently, called me and told me that I thought he was going to kill him. This issue with this medication is ongoing. It's been ongoing for a long time. When I looked back at his 2016 PSI from another violent offense, he talks about he was off his medication then. The follow through with his medication, his mental health is an ongoing issue, as is his alcoholism. I don't think, given his long assaultive history, that this is appropriate. I'd ask the court to continue. Thank you.
All right, based on the seriousness of the underlying charge, the fact that we have a no contest plea, and the fact that the basis for the plea was that Mr. Poyer was either intoxicated, which is indicates a blood alcohol level of 0.20, which is quite high, or was undergoing some type of mental health crisis where he doesn't remember engaging in this activity, that gives me some serious concern for public safety. And given his prior failure to appear, the court finds that bond is appropriately set, and the court is going to leave on what it is. Mr. Poyer, I'm going to get a lot more information through the pre-sentence report, sentencing that might help guide me a little bit in terms of what we do in terms of treatment for you issues. But in terms of a bond issue right now, the court is going to deny the request to modify it. Did you want these made part of the file, Mr. Drew? Or did you want them back?
Yeah, the court can hold them. I mean, I may wind up providing copies to as an attachment to the PSI. But
All right. Where, jury box. How many, who do we have?
I'm sorry, Ben Gonick on behalf of Patricia Super with Cecilia Sarandongo representing her as well.
Okay. Yeah, you can.
Oh, thank you.
Video counsel that I don't think I've ever seen in
So
person.
I was just telling them, I'm pretty sure I've been here before and it's been a long time. Oh, no, not that long.
Oh, no, actually.
That may not have been caught for the record, so both counsel, if you can your appearance.
Cecilia Carandongo on behalf of Ms. Cooper.
Ben Gonick on behalf of Ms. Cooper as well.
Okay, so we're on the record for a couple different matters here today. We have Ms. Cooper's motion to terminate the personal protection order that was entered in this case, and then we have a motion for. And then we have a show cause for an alleged violation of the personal protection order. And just for the record, the court received a request from law enforcement or a complaint from law enforcement for a violation of the order. And then Mr. Bourgeois followed that up with his own filing of a request for show cause. So I set both of them for the record here today. So typically the way I treat show causes, and I'd like to address that first, is I essentially treat it counsel as more or less an arraignment to advise the person accused of violating the personal protection order of their rights, the maximum potential penalties, and to determine whether or not that person wants to contest a violation or admit responsibility. If they want to contest the violation, then obviously they're entitled to a contested hearing, and I set that for a hearing date at which both sides would have the ability to present testimony and evidence, and then the court makes a ruling as to whether or not there was a violation. So it'd be my intention to go through that process with Ms. Cooper here today. Because I view a violation of a personal protection order as relevant to whether or not it should stay in place, I typically will conduct the proceedings on the violation and then schedule a hearing on the motion to terminate following a determination as to whether or not there was a violation. So that's my intention of proceeding. You have a question about that? Well, and I guess I'll say this too, and I do this in every case where there's multiple attorneys. I don't like to get double teamed. So I'll just ask I'll just ask one of you to be the representative for purposes.
Correct, and that's what we'll do.
Okay.
So, Your Honor, if we're just arraigning her, so she would be contesting the violation for the same reasons that she's contesting the issuance of the PPO.
Okay. All right. So, Ms. Cooper, I want to make sure, number one, that you are aware that you do have the right to have a hearing as to whether or not you violated a personal protection order in this case. Do you understand that?
Yes.
Okay. And you understand that if you are found guilty of violating the personal protection order, then you could be found in contempt and you could be subject to sanctions up to including 93 days in jail and or a $1,000 fine. Do you understand that?
Yes.
With that in mind, your counsel's indicating that you'd like to state that you're not guilty or that you didn't violate that personal protection order. Is that position?
Correct.
So the court will enter that on your behalf today, and we'll set this for a contested hearing. Counsel, how much time we would need for that hearing?
Well, I guess it depends what the other side is going to argue, but I wouldn't say more than an hour or an hour and a half or so, maybe.
Okay.
Probably just an hour. And I say that because I think it's very important for the court to have the backdrop for why it got to that point, that then resulted in the violation being issued, if that makes sense. So I don't think the court can kind of hear it in a vacuum. So that was probably why you saw my puzzle, face, because I was used to doing it the other way around.
Okay.
That a court does the motion to terminate first and then proceeds to the violation. I would just ask that we be allowed to, present kind of backwards too, because I think it needs to be put in perspective for the court.
Yeah, I mean, within reason.
Correct.
I presided over an Open Meetings Act
Yes,
matter.
correct.
And so I'm sort of familiar with
Correct.
some of the things that have been going on.
That is
out
correct.
there. So.
And I think that, the latest instances, if you will, I'm not sure the court is familiar with those.
Right. Understood. Okay. Ms. Koch, how much time do you think you would need?
I think we can do it in an hour. I asked the clerk today if we were going to be handling this, if my office was going to be appointed to it, because I wasn't sure exactly what was on the docket. She indicated I was, so I am present. I reviewed it, and I don't think it's going to be a lengthy hearing. So we can do it within the hour.
All right, so I'm going to set it for a 2-hour hearing, just to be safe that you know there's plenty of time. Ms. Koch, do you need any particular period of time to be ready to go forward on it?
No,
Counsel, do you need any particular period of time or just as soon as the court? gets
No,
set?
because I think we were ready to proceed today, so no, except I'm out of the country next week
Okay,
to handle my mom's estate, so I'm not available next week.
okay. So the court will set this for a 2-hour hearing. I'm in trial all next week, so
Perfect.
at the court's next available date. Mr. Bourgeois, it's just important that you stay in touch with Ms. Koch so that you can help her prepare for your case. Do you have any questions about how we're going to proceed at all?
I think I understand it, Your Honor. Thank you. And I will be out of town on the 19th, 20th, 21st of February. So I don't think it's going to be that quick, but just so,
Okay, thank you.
thank you.
All right, Ms. Koch, anything further from your side?
I don't know if the court can address this, but it may be pertinent to future issues, but the PPO that's in place, does the court feel that it limits Ms. Cooper from going to the location where Mr. Bourgeois' office is at the township building in the future so that we don't have any additional problems?
I mean, this is a sticky case, I think, as we all recognize, because Ms. Cooper has certain rights to be at hearings and to participate in those hearings, but those rights don't extend to the point that she's harassing or threatening or intimidating or engaging in prohibited conduct under the personal protection order statute.
And if I may, so the violation, if we're talking about that, that took place during a meeting. I don't think there's any allegations that Ms. Cooper has ever just shown up at random. She just attends these meetings.
Right.
And my understanding from watching a year worth of meetings is that the fire chief comes and there's a written report and he reads it into the record. That's what he does. And then sometimes he makes comments as a member of the public, which oftentimes are directly at her. So I wanted to suggest that if there were issues with people, physically being present in the building, that somebody could accommodate someone, either the petitioner or Ms. Cooper on Zoom or Teams or something like that, if they were concerned about it. But she's never, from what I know, shown up, during outside of those meeting hours.
Yeah.
So it's not like she shows up and is banging on the man's door or anything like that, that I have no record of any of that.
Yeah, and I mean, I don't know, and that's where, the evidentiary part of this is gonna
Correct.
come in, where I'm gonna hear some testimony about what actually is happening, when, and what context. So
Yes, I do know that.
I appreciate your representation, but at this point, I don't know. I haven't heard any testimony, I can't make actual decisions about whether what Ms. Cooper is doing at any point during these meetings or after them is either protected or not, or prohibited under the PPO. So I think that's what we're going to need to get to. So I guess what I would say is, and I'm sure you've already done this, is to just caution your client that she needs to make really sure that what she's doing is going to be within the scope of what's protected and what's not. And obviously, if it turns out that she was engaging in what I find to be protected activity during the course of the public meeting, I won't be able to sustain the PPO violation. But if I don't, then I will. So,
Correct.
yeah, I think everybody's, needs to recognize that this is not going to be a black and white, real clear situation. So I think everybody needs to exercise caution in terms of.
And perhaps we can have discussions with Ms. Cole too.
I think that would be a great idea. And honestly, based on everything that I've heard, I think, counsel, exactly. So. Sense. With each other in the same manner. Exercise their rights and exercise their duties as officials. Fair way that isn't purposely aggravated. Council is. And we have a lot invested and we have a lot of history. That would be my hope. If we can do that before the next hearing, that's great. If not, then I'll take testimony and I'll. That's.
Thank you.
Thank you.
Thank you.